Have you ever signed something and just kind of wondered, what actually makes this thing legally binding? Like an apartment lease, a car loan, or even just clicking I agree on some website? Well, today we're going to decode that fine print. We'll figure out what makes an agreement stick and, more importantly, what can make it completely fall apart.
Okay, so let's just dive right in. At the very heart of any contract that's worth the paper it's printed on is this idea of consent. It's an absolute essential. And it means way more than just scribbling your signature. It's about a real, genuine meeting of the minds where everyone involved is on the exact same page about the deal.
So here's our game plan for this explainer. We're going to start with what free consent even is. Then we'll break down the 5 things that can completely torpedo it. We'll look at some examples and then wrap up with what your rights are when an agreement goes south.
So what does it really mean for consent to be free? Honestly, it's pretty simple. It just means that you agreed to the deal without any unfair pressure or some major misunderstanding messing with your judgment. It's all about the how and why behind your yes.
All right, now for the good stuff. The law actually points to 5 specific things. Let's call them consent killers. If even one of these shows up when an agreement is made, well, that whole contract can be called into question.
And here they are, the big 5. We're going to walk through each one: coercion, undue influence, fraud, misrepresentation, and mistake. You should really think of these as the 5 major red flags to look out for in any agreement.
Our first 2 categories here, they both deal with pressure and power. These are those situations where one person doesn't really have a free choice in the matter because, they're either being forced or seriously manipulated.
Coercion is probably the most straightforward type of pressure. Just think of it as a gun-to-the-head situation, whether that's literal or not. It's basically using threats or actual illegal force to get someone to sign on the dotted line.
And this is just a classic example, right? B might have said yes, but that yes came from a place of fear, not free will. It's a textbook case of coercion, plain and simple.
Now, undue influence, this one's a lot more subtle. It's not about physical threats, it's about psychological pressure. And it usually pops up in relationships where there's a lot of trust, like between a doctor and their patient, or a lawyer and a client.
See, in this case, one person is clearly taking advantage of their trusted position to get something for themselves. It's not a direct threat, no, but it's an abuse of power, and that totally taints the other person's consent.
So, if you want to boil it all down, it's this. Coercion is about brute force or illegal threats. Undue influence is about exploiting a relationship of trust. One's like a punch, the other is more like a whisper in the ear.
Okay, let's shift gears. Our next 2 categories, fraud and misrepresentation, are both about deception. But the key legal difference between them, it all comes down to one little thing: the intent behind the bad information. Fraud is just a deliberate act of cheating. It's when you know something isn't true, but you say it anyway, specifically to trick someone into an agreement. It's dishonesty, pure and simple. Misrepresentation, on the other hand, that's just an honest mistake. You might say something that turns out to be wrong, but when you said it, you genuinely thought it was true. There was absolutely no intention to fool anyone.
And this really gets to the heart of the difference. With fraud, you've got knowledge and deceit. With misrepresentation, you just have an honest belief in something that, turned out to be false. One's a lie, the other is an unintentional error.
So finally, what happens when there's no pressure, no deception, just a huge, fundamental misunderstanding? Well, that's where our 5th and final consent killer, mistake, comes into play.
Now, it's really important to know there's a difference between a mistake of law and a mistake of fact. You know that old saying, ignorance of the law is no excuse? Well, it pretty much holds up here. You can't usually get out of a contract just because you didn't know the law. But a mistake about a key fact, that's a whole different ballgame. And this is where it gets really interesting. If only one person messes up, like a typo in a price, the contract is usually still binding. But if both of you are mistaken about a really basic fact, like you both agree to sell a horse that, unbeknownst to either of you, is already dead, well, how can you have a contract? There was never really an agreement to begin with.
Okay, so let's say you've spotted one of these 5 issues in an agreement. What does that actually mean? What happens next? This brings us to a super important legal difference, whether a contract is voidable or just plain void. So you see, voidable is all about choice. It puts the power right in the hands of the person who was wronged. They get to decide, do we scrap this deal or do we see it through? Void, on the other hand, means the contract is a total nothing. It's invalid from the start. It's like a legal ghost. It was never really there.
And this table really brings it all home. Look at this.
For the first 4 issues we talked about, coercion, undue influence, fraud, and misrepresentation, the contract is voidable. The person who was wrong gets to make the call. But for that very specific case of a mutual major mistake of fact, the law decides for you. The contract is simply void.
So, knowing all this really empowers you to look beyond just the signature line on a document. It pushes you to ask the most important question of all. Was the consent behind this agreement truly and genuinely free?